Well, good morning, good afternoon, good evening. We are here in our second live session with Professor Brand, Chief Counsel Steve Gardner from CLDP, our wonderful VIS advisors, Liz Taylor and Nick, and our wonderful IT director, Kim, who's in the corner. Today, we're going to have a continued session and discussion with Professor Brand analyzing the problem. But before we do, we have a few housekeeping items that we'd like to discuss. Again, we urge you all to make sure you test your system and have your equipment ready. If you'll note that there has been some schedule changes in regards to the practice round and the general rounds, those will be posted, and I think they have already been posted. Each team will receive a letter that provides detailed instructions for how to log on to the RDO system and exactly how to go into the link. In the meantime, we just want to let you know today what we'll be working on while these live sessions are working. We're going to be working with our VIS advisors to prepare for the practice round, to ensure that the system works, and to provide detailed instructions on RDO. So that's our homework today. Your homework is hopefully to prepare. And with that, I'd like to turn it over to Professor Brand to start the discussion. So right now, I think I've given you a list of who's here. There might be others that probably...
AUAF, I think, just joined.
Yeah, I think we have a few other teams that joined. All right.
Okay, is the sound okay with everybody? If it's not, wave at us. Okay, we don't see anything. Okay, it's all right. Okay, good. Well, welcome. We worked our way through all four of the issues yesterday, not in great depth, but I think in the basics. I did ask if anybody had specific questions to send me an email. I got two questions. So my suggestion is we start off with those questions today, and then if there are questions or matters that you would like to anybody would prefer to focus on, we can do that. The first question I received was how can we surpass the merger clause and prove that it does not constitute a derogation from Article 8 CISJ, especially that a merger clause does not generally have the effect of excluding extrinsic evidence for purposes of the contract, according to Advisory Council Opinion number 3. First question here is what is the role of the merger clause? And what impact, if any, does it have on the specific issues? And it can have impact on both the procedural issues and the substantive issues. The merger clause is the final item that we have on page 13 of the contract, Article 22, paragraph 2. This document contains the entire agreement between the parties. That is commonly referred to as a merger clause. Now that's a common sort of agreement in a common law system, and it is intended to mean that you don't have anything outside of the contract that adds to or takes away from the contract. A better merger clause would say that, particularly in light of the CISG Article 11, would say that any amendments can only be in writing in order to avoid oral amendments, because Article 11 allows oral contracts and therefore would allow oral amendments to the contract. But the real question here is, what is the impact of that clause on your ability to interpret other provisions of the contract? And the weight of authority is really two things here. That this type of a merger clause means that you cannot look outside of the contract to add to or take away from the rights and obligations in the contract. It does not mean that you are prohibited from looking outside of the contract for purposes of interpreting the provisions that are in the contract. And so if you look at Schlecht-Friedman-Schwenter, if you look at Honnold and Fleckner, if you look at the Cloud Digest on the sales convention and on Article 8, you'll see some reference to cases under merger clauses, and there have been some kind of odd cases, but the basic concern here is, what does that clause do to your ability under Article 8 to interpret the contract and use the rules of Article 8 of the CISG to interpret the contract? And what it really means is that you still have paragraph 3 of Article 8 that says, in determining the intent of the party, you look, in order to understand what a reasonable person would have thought, due consideration to be given to all relevant circumstances, including the negotiations, any practices which the parties have established between themselves, usages, and subsequent conduct of the parties. So what it means, where that leaves us, is you have the language of the contract. For example, you have Article 21(2), the arbitration clause, and you have Article 19, the liquidated damages provision. You have Article 2, the seller's obligations provisions. You can interpret all of those by looking outside of the contract, looking to the rest of the record. Okay? So I think that probably there's a question, would you or should you spend time on Article 22(2) of the contract? I would say you should be well aware of it. You should be ready for questions about it, but you probably should not incorporate it in what you plan to present, because your time could be spent on other matters and that are probably more important to you in the argument. Let me pause there and see if anybody has questions about that. If you have a question, just turn on your microphone and, okay, we have a question?
Good afternoon. I just have one question, Mr. Professor. Isn't there any possibility that the entire agreement clause bars also the interpretation, and that the entire agreement is a different theory on the common law principles than the merger clause theory?
Yeah, I think there often is confusion about the common law principles and the statute of frauds that allows that, but the common law principles do not prevent you from looking outside of the agreement to interpret the agreement. They often have the effect of a merger clause without even stating one, and that is that you cannot look outside of the agreement to find obligations. For example, if you and if I'm selling you a car and I tell you, hey, this engine is perfect, it's never had any problems, but then we have a written contract that says there are no warranties, okay, that written contract will govern, and if it says there are no warranties, you can't look outside of it to the statements I made to have warranties. That's what this would mean. You cannot create new obligations outside of the written document. You can look outside of the written document to interpret what the words in the written document mean. Does that help?
Yes, thank you very much.
Okay. Other questions on that? Okay, I'll go to the second question I received. This is a question that I'll invite your comments on. from all of you, because I think it's key to the substantive issues. And the question, as I received it, is what is the best way to use Article 19 of the sales agreement for both parties? So let me ask this. If you're arguing for the claimant, how do you read Article 19 and how do you use it in your argument? Anybody want to volunteer on that one, or shall I call on someone? How about USEC? Where is USEC here?
They're on.
USEC 1.
Yeah.
Just takes a
They don't have
minute
their
for
video on.
What's that?
it takes a minute for them to turn on.
Okay.
Well, their video and mic is off. I can turn it on, but they don't.
Do I see a comment coming from USEC? Sure.
Oh, no.
Oh, no?
I mean, they're still logged in. I can unmute them.
Yeah.
We don't have all the teams up on the screen there. Why? is
Not
that?
all the teams are.
Yeah, not a lot of them have their video
They don't
on.
have their video on.
Yeah.
They're hiding it from us.
Yeah.
Turn their video on. It's really,
You
changed
know,
their
we
life.
woke up at 5 in the morning and we're not hiding. It's very easy,
We may not be very wide awake, but we're here.
but we're here. So please turn on all your video. But you have other teams that are here as
Okay.
well.
Okay.
Donna's on.
Hi. Yeah, this is Dana from HBKU, Hamid bin Khalifa University from Qatar. We're not gathering as a group in one room. That's why we're hiding, maybe. So we'd like to thank you all for the effort and the online session. So to reply to Professor Ronald's questions, how to use Article 19 of the sales agreement in favoring the claimant, right?
Their video on.
Is this your question?
Well, the question is, for the claimant.
How can I use Article?
When the claimant had asked, well, what does Article 19 mean to your argument? And this would be the fourth issue.
Yeah,
on,
I think for the claimant, he would not be willing to use Article 19 because it will limit somehow his entitlement to the replacement of the turbine.
Mm-hmm. And so, and for the respondent?
For the respondent, he would like to refer to Article 19 so that he limits the available like remedies for the turbine.
Mm-hmm. And the respondent will use Article 19 to say what? The claimant wants replacement.
The claimant wants to use the CISC so that he say we want the replacement of the turbines, but the respondent would like to stick to the Article 19 because they will claim that we intentionally was willing to derogate from the CISC in the sense of limiting the remedies to those only available under recovery.
Okay, let's dig down a little bit into this. Then if the respondent says, and the respondent looks at this and says, well, Article 19 is here because it was meant to limit our liability. And it says both liquidated damages and limitations of liabilities. Clearly, most of the text deals with liquidated damages, specific amounts due in specific circumstances, and focuses on damages. It doesn't focus on specific performance. So the claimant responds and says, well, it says nothing about specific performance. We're talking about Article 46(2), the right to claim replacement goods. That's in the nature of specific performance. Now, you can argue, and I think maybe some commentators have said that 46(2) and 46, the provisions of 46, that 46.2 and 46.3, replacement and repair, are not specific performance, because 46.1 specifically says the buyer may require performance, so that 46.2 and 46.3 are something a little bit different from specific performance. But no matter how you look at that, they certainly are not damages provisions. And so for the claimant, the argument is, well, we limited ourselves, but we limited ourselves only as to damages, and now we're not asking for damages. We're asking for a different type of remedy. There is no such limitation here. And can somebody take that a step further and tell us why that is or is not an effective argument for the claimant? If the respondent says you limited your remedies, limitation of liabilities, our liability to you is limited. The clause title specifically says that. What's the response to that on the part of the claimant when the claimant says, we want to go to 46.2, we want to exercise the right to get replacement of the turbines? How about Pristina? Where's Pristina here?
We're on.
They are on.
Are they on?
Mm-hmm.
Hello, can you hear us?
Hello, how are you?
Good, thank you. So the way that claimant will argue Article 19 is that the overall amount, which it is included in the second point of Article 19, is that the damages may not exceed $5 million. In our case, considering the facts of the case, the overall amount of the damages will exceed $5 million. So that is why claimant is entitled to request the replacement of the turbines, also in accordance with Article 46, paragraph 2.
But if we look to paragraph 6 of Article 19, it says the overall amount of damages is limited to $20 million. Would replacement cost more or less than $20 million?
Well, if the tribunal award is that the respondent should fabricate the new turbines, and in case these turbines are not prefabricated, then the overall costs will go to $24 million. So again, it will exceed the amount of
24.
million.
How do you come to $24 million?
Calculating the amount that both respondent and claimant will have to pay the penalty. And as we know from the
Okay, and
facts,
where do you find that? Where in the record do you find the numbers that give you $24 million? Is that the same number everybody else comes to? And that's the point of Article 19. If it will cost more than $20 million to replace, then the respondent's argument is, then the contract says we can't do that. We don't have to because our liability is limited to $20 million, right?
Yep.
And the claimant says what to that? I mean, there is a point in the record where it says the respondent, it would cost the respondent $14 million to produce each turbine, and 14 and 14 is 28 million. Although the purchase price of 2 turbines is how much? It's 40 million. That would seem to indicate that the profit is $12 million on this. But so we can look at it in terms of what would it cost the respondent, or what would the claimant get in terms of the value. But we're still left with the question, how does Article 19 affect the argument even if you can make those calculations, does it mean that no matter what remedy we have, it cannot cost the respondent more than $20 million? Is that what it means? That's what it means if it applies not just to damages, but how do you use the sales convention, if you're the claimant, to say that it applies only to damages and we're not asking for damages. Therefore, it doesn't apply at all. Who has an argument, who has a response to that question? Because that's particularly important, I think, to the fourth issue here. And we didn't get clear through the fourth issue yesterday. Yeah, I see, who's down in our lower right-hand corner?
That's Iraqi, yes.
Yeah, the Iraqi team.
The Iraqi group, please tell us. It's all three teams?
I think Al Iraqi is on there.
Al Raqiya?
They're separate, I think, but Al Narain is.
Go ahead, we can't hear you.
Okay. Is your microphone turned on the computer?
It is turned on.
Yes.
Ah,
Nope.
Oh.
Try again.
Can I try to weigh in on this point? I just have an idea I want to throw out.
Oh, Salim.
okay,
Yes.
who do we have?
Salim, TCVR.
Okay, yes.
So we know for a fact that basically respondent ultimately accepted the arbitration agreement based inter alia on the condition that they can insert this entire agreement clause into the contract. So can we say that this entire agreement clause can somehow limit the powers of the tribunal in the sense that it limits the scope of arbitration agreement, and therefore the tribunal does not have the power to order specific performance which is not expressly included in the contract? That's my question.
Ah, interesting question. Does Article 19 affect the interpretation of Article 20, paragraph 2? Does it change the scope? Now,
And just to add one thing on that,
21, paragraph 2.
if I may add one idea to that, is that if we were to look at this arbitration agreement, I mean, it was going to be imposed on the respondent until the respondent somehow got what it wished for, basically by inserting this clause. So it should be respondent's submission that when the tribunal interprets or examines its own powers under the contract, etc., it's only fair to take into account that entire agreement clause, especially that entire agreement clause conditioned respondent's acceptance to go to arbitration ultimately. So just throwing that out there, I don't know if it can be used by respondent to limit the powers of the tribunal.
Yeah. To our teams, does anybody have a response on that? We're still getting the Iraqi group wants to talk here.
Yes, their microphone is still not
The
picking up.
Iraqi group, we can see you waving, raising your hands, but we can't hear you.
Your
Can you
mic-
turn on your microphone, please?
Yeah, it's on, but we're not getting any sound from
We're
you.
not getting any sound from you.
No sound, no.
It's not picking up.
What do they have, a separate microphone there?
I think
Yeah, I think they have an external mic. Yeah.
You have an external microphone.
Maybe you
Is
can
your-
take that off
Is your
and-
computer switched to the internal microphone or the internal microphone at this point? It seems to be something.
Oh, now you're on.
Okay. Whoop.
now we hear you. Hold on.
Whatever you did worked for a second.
No, now it's
It
gone.
came on, but it went off.
Oh,
Nope.
can't hear you.
Still nothing.
If it's plugged into a computer, you should try unplugging the external microphone and using the computer microphone. Or switching your settings.
This is important. When you have your arguments, make sure that if you use an external microphone, that's not just the microphone in the computer, that you change your settings so that it's set to the external microphone. Test your computer before you log on.
What did they do yesterday? They just went up to the computer
Yeah,
and walked
Yeah.
up to it.
yeah.
Yeah.
Well, we can
Yeah, it's
try.
not picking up.
Okay, we're still
Until
not
they
getting
try.
it. So I'm going to go ahead here.
Now, can you hear?
Okay.
Now
here
we
are.
can hear you. Ah,
It went on for about a second and it went off.
oh, you're
Very
on, you're
sorry.
still on.
We have a response about the limitation clause of the clause 19 under the contract.
Can you turn up your volume on your microphone a little bit?
Or speak closely to it.
We have a response about the limitation clause of clause 19 under the contract.
Yes.
Yes, even if there is a limitation clause under the contract that restricted the respondent liabilities, but the respondent, even that it can't depend about this limitation clause, that limitation clause, it is a clause involved into the convention, but not settled by that convention. So because of that, we have a gap in this case, we have a gap. So we have to fill in this gap by going to the Article 7.2 of the CISG, that there is some question that they involve into the convention and didn't settle by this convention. So in this case, we will go to the principles of the CISG, and our principles for this case is the unit right principles that the parties agreed upon in the record 46 clarification 4, that the principles for this contract shall be the unit rights principles. And under Article 7.1.2, even if there is a limitation clause, the other party cannot depend about this limitation clause if its obligation referred to its negligence. And because of that, respondent cannot depend upon this limitation clause that he negligence its duty, that he couldn't involve my client with the certificates of equality. And you can find that in the record 15 in our case, that due to a mistake in the responding management system, it can't be determined with certainty which is still used in interaction. So because of that, he can depend upon the limitation clause.
Okay. Let me back up a little bit on that because there was a lot there, and I appreciate that. You've tried to track through things rather nicely now. But a first point here on Article 19, when you say there's a gap, you say there's a gap in Article 19. Is that what you're saying?
Yes,
Okay.
we interpret.
Okay, then the question is, where do we go? And if there's a gap in the contract, you look to the default law, and the default law is the sales convention. Now, you want to be very careful. Article 7 and Article 8, it's important to understand the relationship of those two articles. Article 7 gives us rules of interpretation, but it's rules of interpretation for the sales convention. Article 8 gives us rules of interpretation, but they are rules of interpretation for the contract, for determining intent of the parties. So if we're interpreting the contract, we must look to Article 8. We use Article 7 only to interpret the sales convention, and Article 7.2 then tells us what happens if we have gaps in the sales convention. Now, on issue number 4, would claimants say there is a gap in the sales convention? The claimant would say, no, 46.2 gives us the right to get replacement goods, okay? But the concepts here are similar, but I would track through it a little bit differently here. If we start with Article 19, the question is, what does Article 19 do? And if we go to the claimant will say, well, Article 19 limits damages, but we're not asking for damages, so Article 19 doesn't apply. The respondent will say, well, Article 19 limits liabilities. That includes damages, it includes specific performance, it includes replacement goods. So then how does each party go the next step and back up their basic argument on Article 19? And there's a provision we haven't looked at here, because what claimant says is we're relying on the sales convention. The sales convention is the default law. That's the law unless we have changed it, and we haven't changed that. The respondent says, yes, Article 46.2 is the default law that would apply if we didn't have anything else in the contract, but Article 19 is in the contract and it did change 46.2. So, but where do we go from there? Is there anything in the sales convention that helps us determine if Article 19 did or did not change 46.2? What in the sales convention governs whether the parties have changed the rules under the sales convention? Is there anything?
Yes.
There, I have a.
Okay, I have
What
a
is it? What is it in the sales convention that governs?
Yes, we can depend on. Hi, do you hear me?
Yes.
Yes.
Yeah. My name is Hajar Ahmed. I'm from Nahrain University. I think we can depend on Article 6, which indicate that the parties are free to exclude or derogate any provision impliedly or expressly, even if the parties agreed about that in the contract. And when the parties agreed about liquidated damage and liquidated limitation of damage, I think this is impliedly derogation for Article 46.
Good. Article 6 is where you need to go. And Article 6 tells us that the parties may exclude the application of the convention or derogate from or vary the effect of any of its provisions, which means you can derogate from Article 46 too.
Yes.
So that you can derogate. Then the next question is, did the parties derogate? And how do we, is there anything that can help us determine whether we know they can derogate? The question is Article 19 a derogation from Article 46.2? And the claimant will say, no, it's only a derogation from those articles that provide for damages. The respondent will say, it's a derogation from all of the provisions that provide for remedies. And it limits the remedies to exactly what we have here. So how do we help the tribunal write the award on that issue, on that distinction?
I think there's no derogations. There are two derogations. First one about the suitable goods, the derogation in Article 20 in the contract. And the second derogation about the specific performance in Article 19 from the sales agreement.
Okay, yeah, Article 20 and the procedural order number 2 tells us very specifically that Article 20 is intended to be a derogation from the normal standard for determining fundamental breach, and that it lowers the burden of proving fundamental breach from what is entitled to expect to deprive the buyer of what it is, substantially deprive the buyer of what is entitled to expect. And so we've got the derogation under 20, but if we're arguing a derogation under 19, what the respondent will say, yes, it's a clear derogation. Article 19 clearly deals with remedies. It limits remedies. We don't look at the remedies provisions of the sales convention. They have now been derogated from. We leave them out. Claimant says, no, we don't leave them all out. We only leave out those that deal with damages. Not all remedies. That leaves 46 in. How do we resolve that debate? Is there anything that helps? First, the question is there anything in the explicit language of the convention that helps us resolve that debate? And I think the answer is no. But there is more in your research in the cases that apply Article 6 that deal with that. And you're going to have to reason by analogy here in many of those cases. Certainly, most commonly, Article 6 is raised when you have something like you have here in Article 21(2), the last phrase that says the governing law of the contract shall be the substantive law of Danubia. Now, Danubia is a party to the sales convention. It also has its own contract law. What does it mean? The governing law shall be the substantive law of Danubia. And you all know from your research that courts and tribunals have looked at that. And if you choose the law of State X, and State X is a party to the sales convention, the cases have become quite uniform, although they weren't at the beginning. They have become quite uniform to say that the law of the State X is the sales convention. And if what you intend when you draft that contract is to go to the domestic sales law, you must say that expressly. In other words, you can derogate from the sales convention, but you can only derogate expressly and explicitly. Okay? So how do those cases then help the claimant in this case? And you should go to the UNCITRAL Digest, and you should go to Schwenzer, and you should go to Fleckner and Arnold, and you should be able to cite them for, and they list the cases on this issue in Article 6. But courts and tribunals, arbitral tribunals, have routinely now said, look, if you're going to derogate, the derogation must be explicit. If it's not explicit, you haven't derogated. So you see how that helps the claimant. The claimant looks at Article 19 and says, yes, there's a derogation. There's an explicit derogation from damages remedies, but there's no explicit derogation from specific performance remedies. And if there's no explicit derogation, then under the case law on Article 6, there is no derogation. Do you see how that works? And that's the argument that the claimant has to make in response to the respondent saying, we have Article 6 or Article 19, it limits all remedies. And let me ask this, I'll give you all a chance here to do that one zinger sort of rebuttal. If the claimant or surrebuttal, if the claimant on its rebuttal has focused on Article 6 and said derogations must be explicit, what's your last point you want to make as respondent? Somehow you want to say Article 19 is explicit, an explicit derogation from all remedies in the convention, right? You won't find that in the text, but you'll find it in the title. It says limitation of liabilities. Liabilities include liability for damages, include liability for replacement, include liability replacement for repair. That's explicit. And you would have to try to rely on that. Okay? Are there other questions on Article 19? I think we've kind of taken it through. Those are the only two questions I received by email. Are there other questions that, as you've thought about this in the past day, or that we didn't get to yesterday, or that you're struggling, particular issues that you're struggling with in terms of putting your arguments together? Anybody, feel free to put on your microphone and let us know. Not getting any.
Maybe one.
Getting one there?
I see people moving.
What? Yeah.
I think one of the Iraqi teams had their hands up.
What? We lost the video.
Wait, we can hear
Okay,
you though.
Iraqi team, please go ahead.
Yes, yes. Professor, I have a question that about Article 19, the limitation clause. Can you hear me?
Yes, but yeah. Go ahead. I'm not sure if you can turn up the volume on your mic a little bit, it would help. Go ahead.
Just 1 second, you are getting closer to the microphone.
Professor, I have a question about the limitation clause on Article 19 of the sales agreement between claimant and respondent. I present the claimant on the substantive issues. So we try to prove that even if there is a limitation clause, respondent have to do its obligation under the contract by delivering replacement turbines by going to Article 46. So I made a research about it, and the limitation clause did not settle by the convention. It is involved into the convention, but didn't settle by it. So we want to go to the principle or the principles of this contract, or the principles of the CISG, which is the unit right principles. That I find that under Article 7.1.6 of the unit right principles, even if there is a limitation clause, this does not prevent respondent from doing its obligation to deliver replacement turbines. That if the parties who fails to perform its obligation by going because of its negligence, it has, even if there is a limitation clause, it has to do its obligation, which is the obligation that the other party choose. So can we depend upon this authority?
Yeah, if in order to get to the UNIDWA principles, you have to demonstrate that there has not been a derogation from the CISG. So it'd be a two-step process. You would say the CISG has not been derogated, but the CISG has a gap, and therefore we go to the UNIDWA principles under Article 7, paragraph 2, interpretation of the convention. Now, that's a little bit difficult, I think, because I think for claimant, you say there's no gap in 46.2. We get a right to replacement, and that's all we need. But claimant has to prove that you're still, the important thing is you have to prove you're still in the convention, that you have not derogated from the convention under Article 6. All right? Now, there's still one other possibility here that it gets a little more complex, but I think when you look at, part of what you can do is you can look at the numbers and you can play with the numbers and you compare the $20 million limitation to what it would cost plaintiff to go ahead. But what it says here is limitation of liabilities. So let's assume that the tribunal decides, number one, that Article 19 clearly limits damages, and number two, that it also limits specific performance when they say limitation of liabilities. That would seem then to place the claimant in a very difficult position, because then all they get, the maximum they can get is the $20 million under paragraph 6 of Article 19. But there is another way to track through the sales convention that might work for the claimant. And that is, and in particular, because Article 20, paragraph 2 has reduced the standard for fundamental breach under Article 25. And if you look at Article 49, it says there's one other possibility. I mean, you can allege breach, claim damages, you can allege breach, claim specific performance, but you can allege fundamental breach and avoid the declare the contract to be avoided under Article 49. And think about this for a moment. If the claimant declares the contract to be avoided, what's the result of the declaration of avoidance under the CISG?
We will go to the Article 49 to avoidance the contract. 48, sorry.
But the result of declaration of avoidance under the CISG is that parties go back to where they were had there been no contract, which means that the respondent gets the turbines back. That's kind of difficult in this case, and that's probably not what the claimant wants. But what does the claimant get back?
Money.
Their money. How much? $40 million. Not the $20 million, $40 million. So if they claim breach and request damages or specific performance, if Article 19 is limited that to 20 million, they just say, well, we'll declare the contract avoided. We get all of our money back. We get 40 million. We're being really nice to the respondent by simply asking them to replace the turbines, and we know that they can produce 2 new turbines for $14 million each. That will only cost them $28 million. You see the argument there? It's kind of a third approach. It's not damages, it's not specific performance, it's avoidance and going back to the starting point on the contract, which means the goods go back to the seller, the payment comes back to the buyer.
Yes, Professor. Thank you very much for your effort. But when I go to this process, when I'm going to the unitary principles, that if we ask for the replacement turbines under Article 46, it is simply that the respondent will allege that we can derogate this article under Article 6 of the CISG, because if there is a limitation liabilities into the agreement between the parties. So what I trying to prove that even if there is a limitation clause, this is does not deprive my client from depending upon Article 46 of the CISG.
Yeah, well, what you're doing at that point is taking the limitation clause and it's really an Article 6 analysis, trying to decide what provisions it derogates from and what provisions it does not derogate from. And so what provisions of the convention still apply and what provisions of the convention no longer apply and have been replaced by that provision in the contract. Okay?
Thank you.
Does that help?
Professor, I have a question. That we can not apply this article because there is there was not any fundamental breach, not by derogation. We can depend that this article is not applicable, not by derogation, but by there is no fundamental breach in our case.
Well,
can we depend on that?
Okay, but keep in mind that fundamental breach is a concept that you can still, you can still, for example, get damages without fundamental breach. All right? Note, for example, if you look at Article 74, 75, and 76 of the Sales Convention, okay? So Article 74 gives you the discussion of damages, and there's nothing in 74 that requires fundamental breach, okay? Now, Article 75 and 76 both start out with the phrase, if the contract is avoided, okay? And you can only avoid the contract if you have fundamental breach. And 75 gives you a right to contract price versus to purchase substitute goods and do a contract price less substitute goods price. And Article 76 is a difference between contract price and market price. Those measures of damages apply only if there's fundamental breach and avoidance, okay? But Article 74 still allows you to get damages without fundamental breach. So there are times under the convention where you can get damages. Fundamental breach is a concept that takes you to certain remedies, but there are still remedies that you can get with a breach that's not fundamental under Article 25. So, but first of all, you've got a reduction in the standard necessary to prove fundamental breach in this contract, but you also have some damages that can, including loss of profit and consequential damages under Article 74 that are available even without fundamental breach. So not all damage remedies require fundamental breach, and then the question is, well, and if you look at liquidated damages, they refer to downtime, and they would likely be in the nature of lost profits, which may be the kind of Article 74 types of damages in some cases as well. So, questions on that? How about from the other teams? Are there any questions? I see a hand coming up. Go ahead, hit your microphone and yes.
Once again, Mr. Professor, I had another argument for the claimant. So, what is undisputed is that liability is much more broader than the damages. But damages are part of liabilities. What we have is a title that limits the liabilities, but in the concrete provisions of the Article 19, we have the liability limitation for only the damages. And here another question arises. Does the title of the article itself constitute any obligations for the parties or not? Because if not, then only the explicit provision of Article 19, which limits the damages, can be applied between the parties, and not the much broader limitation for all the liabilities.
Yeah, that's an interesting question, and that goes to interpretation of contracts as well as interpretation of treaties and sales convention. And the question for treaty interpretation often is, do the headings to each article represent substantive rights? And the same thing in the contract. And here you can look at it two ways. One is that the heading itself has substantive effect. The other is that it on its own doesn't have substantive effect, but it helps you interpret the other provisions. And that's the general approach to, for example, to the introductory provisions, the whereas clauses in the sales agreement as well. And so I think you argue that whether or not they have substantive effect on their own, they have effect in helping, I guess, determine what the rest of the world, what the substantive terms themselves mean. Does that make sense in response to the question? And so, in other words, the respondent would say, well, look, we don't need them to tell us what it means because everything in the substantive provisions of Article 19 simply limit damages. And the claimant would say, well, we do need it to tell us what it tells us that, or the respondent would say, we do use it to tell us what it means because it makes clear that we've limited the remedies to damages, but those are the only remedies that are left because it's limitation of all liabilities. And the claimant would say, well, look, if we look at the text, there's no ambiguity, it's just a limitation of damages. We don't need to go to the title to help us out. And you simply have to argue that, do you get to a clear answer either way? The answer, not necessarily. So you have to make the best argument you can. And that's the way the problem is drafted on just about everything. You come straight down the middle for claimant and respondent, and then we get to your advocacy skills to help us get a decision on that. Do we need to move on to the...
You have 2 more minutes to...
Thank you very much.
Kind of, if you want 5 more minutes, I can give you 5, but...
I think... Yeah, go ahead. We have
just, a few more questions and some
okay.
housekeeping.
David, did you have something more?
Yes. Good morning. Thank you for waking up.
Okay, we'll hear from Karthik here.
Yeah.
Yes.
We have 2 questions. The first question is about the possibility of including the tender documents through the doctrine of incorporation by reference.
Say that again.
Incorporation by reference.
Yeah, but what's the question regarding incorporation by reference?
Since the tender documents are mentioned in the preamble of the sales agreement at least 2 times, could we consider that incorporation by reference?
So which documents does the preamble incorporate, would incorporate by reference?
So, the tender documents.
So midway through the preamble, it says, whereas Hydro EN wants to participate in the tender.
The tender documents, wants to participate in the tender. Well, there's a difference between incorporation by reference and using external documents and statements to interpret the contract. Okay, I don't think you can say that the tender documents were incorporated by reference, but I think you can say that certainly the purpose of this contract was to help one of the parties win the bid with the tender documents, right? And so that the whole tender process is important to understanding what this contract means. Now, you cannot use that to change the terms of this contract. You cannot use it to add or obligations or remove obligations, but you can use it to interpret the obligations and define them as to what they are. Does that help?
Yes. Perfect. Thank you. Just one more question for my...
Okay.
Yes, thank you. May I refer you to Article 20.6 of the LCA rules?
The
LCIA rules?
The LCIA rules?
Yes, 20.6.
20.6.
It is said that even a party can be considered as a witness. The question would be that, can we use this article to say that a conflict of interest is not a reason to exclude an expert witness?
Well, even a party to the arbitration can be a witness. So a conflict.
Yesterday we used Article 20.3.
Yes.
The LCA.
Well, I guess, do you need 20.6? It seems to me 20.3 is the rule that tells you that the tribunal has the discretion to include or exclude Professor John in his testimony. But you're told, and that's how they can deal with witnesses. But we know that Professor John is an expert witness. Does it make any difference does it change anything if we look to 20.6 then? What would it change in our analysis?
Well, that Article 20.6 gives the possibility to a party, which means that a party to the dispute, there is a conflict of interest, like itself has interest in this case. So maybe making an analogy and saying that, or making us understanding that the conflict of interest may not be a reason to exclude Professor John, an expert witness, which means that taking into consideration the discretionary power to the arbitral tribunal, whether to accept a testimony, a written or oral testimony, maybe conflict of interest shall not be taken into consideration while they are while they have the power.
Yeah, well, I read 20.6, and you may want, if you have the book on the LCIA rules, you may want to see how it's interpreted there. But it's I read 20.6 to say that, look, a party or an employee of a party, if it's a corporation, may be a witness. Now, that doesn't answer a whole lot of other questions that come with that. If they are a witness, how do you treat their testimony? And certainly, if you have someone who's the CEO of one of the parties, you're going to assume that their testimony is presented in order to support their case. And that's very different than having the testimony of a third party who is completely neutral in the case. So it wouldn't go to whether or not you would admit the evidence. It would go to what weight do you give to that evidence of that person, because they have a clear relationship. Now, in this case, Professor Johns clearly has a relationship with the party that wants to have his testimony be considered. But it's not the relationship as an officer, employee, owner, or shareholder of the party. And so I think the tribunal can take into account the nature of that relationship. And this is often the case with expert witnesses. On cross-examination of expert witnesses, you will get questions about, well, how many times have you served an expert in the past? And how many of those times have you been an expert for this party who has brought your report to us here? And if you've been an expert for the same party 50 times in the same type of case, well, then you're pretty closely related to that party, and you can use that on cross-examination to impeach the value of the expert's opinion. But that goes to the weight of the evidence, not the admissibility of it. And I see 20.6 simply saying the tribunal can consider as witnesses anybody, including employees and officers of one of the parties. But that doesn't tell us what weight they will give to that evidence. I hope that's helpful.
Thank you very much.
Thank you.
Yeah, I think,
Liz,
Liz, why don't you take a moment to talk about
Yes.
this advisor sessions?
Okay, so
Let me just say thank you. Good questions. I appreciate your discussion. I hope it was helpful. And so you now have some nice opportunities for the rest of the day to work with the rest of the team here.
Okay, so now we're going to log off of this session and begin the VIS advisor sessions. As the email suggested yesterday, There will be 4 sessions according to each of the subsections of the procedural order. So your team can split, and if you have access, for example, on your phone, you can log in. If you're the procedural person, you can log into one or the other procedural session. Room 1 is going to handle issue 1, room 2, issue 2, and room 3, issue 3, room 4, issue 4. And there will be 2 sessions. So this session will go beginning in about 3 minutes for 2 hours, and then we'll have about an hour break, and then we'll begin the next session. So if you're on substance or if you're on procedure, you'll be able to work on a BIS advisor session on each sub issue. We would expect that most people will want to do one and then the other in the next session. But teams, feel free to pick whichever session you like. The advisors are going to be in contact with each other. So if we're too many teams in, for example, 3 and not as many in 4, then we may ask people to switch around, but it's up to you what you'd like to see first, and we should have 2 advisors per session. Each one's going to do slightly different breakout type exercises, but it won't be a pleading and it's not simply going to be a Q&A. So feel free to log into those advisor sessions if you guys have any issues. The links to those were sent out yesterday, and I think maybe again this morning.
Yeah.
But, the links to those are accessible. They're all on the schedule, and we will log out now of this. And
Well, wait, a few more things. Again, we are realizing that there are some connection issues with your equipment. In order to prepare everyone for tomorrow's practice session, as I said, we have the session on RDO. It won't be through Zoom, but it would have almost the same connection. In that light, I see today that we've only have, I think, like 18 of the teams out of the 28 teams. So 10 other teams were not able to log on or did not log on. Additionally, even during this session, we had some connectivity issues. So just before, I'd like to take a roll call to understand how each team plans to do the practice round, either individually or together as a team, and whether you have all your equipment. So I'll start with UAE.
Yeah, hi, can you hear me?
Yes.
Yeah, we're actually gonna meet as a team for the practice sessions.
In one room?
Yeah.
Okay, do you have headsets for everyone?
Yeah,
Laptops for everyone? A location that's quiet?
Yes.
Okay, I urge you to test that equipment today, prior to the practice round.
Sure.
And because tomorrow is it, that's it. Whether the connection works or not will be dependent on your team's ability to do so. And that goes for everybody, but I just want to check how each team is connecting. Great, thank you, UAE. Tunis, how do you plan to connect and where?
We have the Common Law Center that is only dedicated for this competition, yes. So we will be as a team.
Will you have 2 separate rooms depending on your hearing?
No, we will be only in one room.
Okay.
We have headphones.
Okay, check the general schedule because there might be, for everybody, there might be in the schedule for claimant going on one round and respondent going in another same time. So that might affect some teams. So you might need 2 rooms. All teams should have at least 2 spaces in order to do that if you're doing it as a group team. So thank you, Tunis. Christina? How do you plan to connect?
Yeah, they might log out.
They are not logged in.
They're logged in. Okay, so we don't know. Mustar?
We'll be pleading in one room. We only have 2 counsels on respondent and claimant, so.
Your connection has been pretty good so far.
Great.
Colombo University? How will you be connecting?
We can't hear you.
We can't hear you.
We'll be connecting from one room.
Okay, so your connection, there is sometimes a delay, and you might want to fix the settings on how watch Nick's video on virtual pleadings. Extremely important. If you haven't watched the video sessions that have been pre-recorded, that's your homework tonight. Our VIS advisors have spent significant time volunteering to watch those. Nick gives an excellent video on exactly how to prepare for your pleading and making sure how do you position yourself and what area you should be in. So make sure you do that tonight. Great. Yangun? Are they on?
Oh, there she is.
Oh, yes.
Yes. Nadine, will your team be, no, sorry, I mean, will you, that's not Nadine, but that's, yeah. Will you be connecting individually or as a team?
Individually.
Okay. Please make sure that all your teammates can connect with their headsets and that they're visually have clear backgrounds and that their voice and video work.
And make sure that there's close feedback.
Yeah. And Yusek, will you be joining together as a team or separately? We've had some connection issues with Yusek.
No, we will.
I don't know if they're still on.
Hello, can you hear me?
Yes, I can hear you.
We apologize for the technical difficulties, but yes, we'll be meeting as a team tomorrow at our university. We will have different rooms for both
Okay,
counselors.
how will you work to ensure that you have video feed?
We have 4 different laptops and the university's Wi-Fi, so I think we're good. And we will use the projections in the classes that we'll be using.
Well, just make sure that you test that today. You can use that with the VIS advisors because the Iraqi team, for instance, tried to buy new cameras and mics, and that worked at the end, but it took a while to integrate the system. So please test it now.
Yeah, we already tested yesterday when we watched the session. So
well, we could have used it today. So try
no,
to use
because
it with your
today
VIS advisors now, so that way we can see you.
No, because today our access to the university was restricted because of the corona virus.
Are you going to have that same issue tomorrow?
No. It was just today. They were fixing everything for the coming days.
Okay, well, I would have a plan B.
We do have the plan B, the office of our advisor.
Good. Maldives? Are they on?
Hello, can you hear us?
Hi.
I will be connecting, not individual, but together.
Wonderful. Again, watch Nick's video. I think it's good. So far, your connection has been very good.
Yes.
But we just need to, if you're going to have your claimant or respondent, make sure you have it per team.
Yeah. Thank you so much.
That you have, because if, just in case you are doing claimant respond at the same round, so you'll need 2 spaces.
Yeah.
Great. Thank you.
Thank you.
Georgia? I think we've had good connection there. I'll connect to the Araqiya later. Dar Hikma is okay. AUAF said they're on. I don't know if they're on. We have not seen them.
Your video and mic is off.
Your video and mic is off.
There were a couple AUAFs earlier, but
Tehran, we had 1 decent connection. Skandaria, yes.
Whoever is talking, we can't see. Oh, no, we can't.
Oh, hello.
There's a little delay on it.
Sometimes there's feedback and it's because your mic is either too high or too low, so make sure you test the system.
You should be using headphones if at all possible, because when you have to have your computer volume on and up in a room, it creates a feedback loop.
In the next VIS advisor sessions, everyone's video has to be on. Okay. All right. If anyone else, if you have any further questions, you'll receive an email today. And tomorrow is your practice rounds, 1 dry run. So we wish you all good luck. You have a lot of homework today and a lot of homework tomorrow. And please take a moment to watch all the VIS sessions that our advisors put up. We'll have more put up today. And hopefully you can all take advantage of the VIS advisor sessions that are happening now. So without any further comments or questions, yes. I can't hear you.
I hear you.
Still can't hear you.
The microphone may not be turned on.
They are not, she's not muted, but it's not coming through. You may need to turn up the volume on your microphone or activate it.
Do you want to type in your question?
Hold on, video off now. Her mic is on, but not picking up. Everyone knows that there's a test microphone feature on Zoom and on these things. So when you log in for the first time or when you open up a session, it'll give you the chance to test your microphone. You should all do that and make sure your microphone is picking up sound.
How many minutes earlier should you be logged into your practice rounds or your rounds?
So
15 minutes.
she was saying she's from the Boise State University regarding the reschedule of the timetable. Is it possible?
We just sent out a new schedule.
It's quite impossible unless it's a security issue. We have really went backwards for teams because of security issues and government restrictions on movements. At this moment, the general schedule can now no longer be changed.
Yeah, unless it's a security or a
Just remember, this is international commercial arbitration. This is virtual international commercial arbitration, which means that some people have to wake up at 1 a.m. and look like it's 9 a.m. So this is it. This is the experiment. So unless it's a government-imposed restriction on assembly or there is very extreme circumstances, then the schedule is likely not to be changed. So welcome to global commerce.
However, they did send out some updates this morning.
Yeah.
Salim sent an email this morning. There is a slightly updated schedule, so please confirm that the times are what you expect them to be.
Yeah, the new schedule's already up. We
Yeah,
talked
it's
about
already
that,
posted,
yeah.
So, okay, should we switch?
All right, we need to get to your advisors. They're patiently awaiting. Good luck.